The advent of the new Federal Rules of Civil Procedures and amendments to the discovery rules has caused a veritable tsunami of new decisions that involve electronically stored information. And these decisions have been fast and furious, and typically the legal profession has been one of slow and stodgy type of precedent building over a period of years and perhaps decades. Really what's happening now is you're having a slow and stodgy accretion of presidential decisions over a period of weeks. And you'll have a decision that will come out in November of last year that all of a sudden will be cited in 2 or 3 decisions in December. And Magistrate Judge Facciola's decisions represent more than a few of them. So these decisions have also begun to address records management issues, because as we look to how to the evidence that we are seeking to acquire through discovery, and discovery is after a lawsuit has begun and everybody starts asking for information, we're looking for how not only do we acquire this evidence, but what happened to the evidence before it was acquired. And that's where electronic records management comes in.
From that point on, sloppiness may get you in as much trouble as attempting to destroy records. And now to go back to what we were just talking about, there's a very interesting recent decision which states the obvious, and one wonders why it took so long to get there. But the court said, look, we understand you had this thing on paper, and it sounds really lovely on paper. But what we've noticed from the evidence is nobody on earth obeyed any of it. You said that this stuff was to be kept, but nobody enforced it. You said this stuff was to be destroyed, and nobody enforced it. So that would be a classic example where just being negligent and grossly so will get you in trouble. And the mere fact that you're not malevolent doesn't get you. If you do not have a formal retention policy, I suppose by default you're keeping everything. If you're keeping everything, you know that the search for any part of it gets that much more complicated. The reason that becomes of concern to a judge is that when you show up in my court and you say, well, Judge, it's going to cost X millions of dollars to find this, one of the questions I'll want to know is why does it cost that much? And if in the affidavit you file in support of your claim that this is going to be too expensive, you are forced to admit that you don't have any policy with reference to disposing of things, then it seems to me you are the architect of your own problem, because you've created a system which is a non-system, in which everything is retained. Accordingly, the default, let's keep everything because storage capacity is cheap and who cares, actually is not a solution. It's a problem. To go back to your question, I reasonably expect the lawyers who come before me to have collaborated on every aspect of the discovery. Now, it is crucial for you to understand that you must be part of those discussions, and you must be part of those discussions from early on. And if you are not part of those discussions, you should advise the people who go to those discussions that when it hits the fan, they can look for somebody else besides you.
Or even better, perhaps, you could expect that if you don't cooperate early on with your counsel, that you'll be called upon to discuss what happened later on in a deposition, which is a lot less pleasant.
But it is expected. Now, lawyers differ among themselves. There would be a group of lawyers who would insist that the record manager or the IT people who are responsible for records come with them to these conferences and have a thoroughgoing discussion. Certainly, these discussions may be much more profitable if both sides have record managers there. You know, it goes against lawyers' grains to have people at conferences who actually know what they're doing, but this would be an exception to the rule. And the records managers can, by speaking the same language, advance these discussions. I anticipate, if it isn't already happening, it will soon happen, that judges will become quite insistent on that. Andy Rooney said the problem with the world is it's divided into people who keep everything and people who throw everything out, and they keep marrying each other. And so the whole problem when you don't have a disposal, then all of a sudden you're going to have to spend a lot of time looking at stuff to see if it is privileged, when it is at best marginally relevant to the lawsuit. So you are creating a horrifyingly expensive problem. And I don't know why senior management gets away with that. If I were at the controller of a company and I was told that we just got a legal bill for $500,000 because several associates at $250 an hour sat in a room going through email streams to find if any of them were privileged, I think my first question is, why did we keep all that stuff in the first place? Who made the decision? Because whoever made that decision just cost us $250,000.